Good morning everyone. Well, I thought I'd take you through and make a brief couple of videos just to help out all those people that are sick to death of being ticketed for speeding. On the first part here, I'm going to take you through what's called a request for a hearing to the NZPIB, or the New Zealand Police Infringement Bureau. Now, you'll get a ticket and usually in the post. And this stuff works whether or not you've got a speed camera ticket or being pulled over. There are slightly different things that you can request, you know, such as certificate of competency of the cop that pulled you over, for instance, versus, say, the deployment register from the speed camera, where it was deployed that day, how many tickets it got over how much time. Always note on the deployment register that it'll give you a number of tickets issued. The first and last ticket on that is them actually testing it, so it's actually always two less, but that's just never mind regardless. Okay, so you'll be sent a ticket, then you'll get sent something like a reminder ticket here. Then all you really have to do, and I mean, if you want, you can go and, you know, ask for a photo of the vehicle. Usually you'll be sent a photo like that. Clearly you can see who's driving by that photo, can't you? Can you? I can't. I mean, unless you can zoom in on the rear vision mirror and it shows you the face of the driver, that is something for the police to establish. It's because it's a category 1 criminal offence, beyond a reasonable doubt applies, so that is the standard of proof that they have to beat. And I don't know about you, but that photo doesn't say who was driving. Now, they'll say if you're the registered owner of the driver and you weren't driving that day, fill out a declaration saying who was driving. Well, if you weren't in the vehicle and you weren't driving that day, how the fuck do you know who was? Because you were somewhere else. You have no first-hand knowledge of who was driving. You may know who had access to the vehicle, but it's not for you to do their job. Maintain your presumption of innocence and stay innocent. You don't have to give them a declaration. They will use section 133 of the Land Transport Act, saying that it will be presumed that the registered owner is the offender. Well, again, there's one presumption going against your presumption of innocence, and it's all presumption without evidence and facts to support it. So you'll get sent that reminder and that wonderful little picture. You can go online. Usually you just go to tickets or the NZPIB, they'll take you, or the police website, they'll send you somewhere. You just got to put in the ticket number, and usually they'll let you see the ticket online, or at least the photograph online, which, like I say, 99% of the time doesn't even show who the fucking driver was, so it's pointless. Now, the points they have to prove is that it was you driving the vehicle on that day at that time. That's it. If you want to say, hey, look, I wasn't driving that fast, congratulations, you've just admitted that you were the driver. But if you say, I don't answer questions, what evidence do you have that I was the driver? And they want to donkey dick you around and assign duty lawyers and amicus curiae that will just sit there and argue with you and say, look, you know the crux of the matter, were you the driver? It is not for you to answer their questions either. If you tell the duty lawyer, you tell the amicus curiae if one gets appointed, they will turn around and go straight into the court and say, Your Honour, the defendant has admitted they were driving. Because they have a first duty to all of their other lawyers, cause the other lawyers no harm, and to the court, not to you. Alright? Duty solicitors were getting paid an extra $100 if they could go in and just get someone to accept a guilty plea. They got $100 backhand. They get $70 for every person they represent, which may be as simple as standing up and going, yeah, not guilty, Your Honour. Great, $70. But until recently, there was a couple of courts in New Zealand where the duty solicitors were being paid an extra $100 if they could talk their clients into taking the guilty plea straight away. Why? I think it's because it's corrupt. Their argument might be, well, we're just trying to speed up the court process and get those guilty ones through. Well, what happened to your presumption of innocence? Anyway, so first off, what you do is you send them a letter to the Police Infringement Bureau like that, right? and you're basically saying that you believe that the police have made an error, that you'd like to gain resolution. Now, under the Summary Proceedings Act 1957, Section 21(6), a notice or you sending a letter in writing requesting a court hearing is deemed to be a not guilty plea. So the sheer fact that you're requesting a hearing means that you're going to get a hearing and you're considered not guilty. I'll let you have a look at all of these documents, and these documents are all, what I've done is I've created, well, I'll show you the folder. There's things called authorities. The authorities are what I refer to in the footnotes. Now, the authorities have more power than the actual legislation under the doctrine of principles, okay? So you might be getting frustrated that you're mentioning sections of law and they're taking no notice. You put it in as an authority or in a footnote that you're referring to, that gives it more power. They have to look. All right, so you can go through all of that. You in the first letter you're referring to, like I said, Summary Proceedings Act 1957, Section 21, subsection 6. You refer to New Zealand BORA 1990, Section 25, which is the minimum standards of criminal procedure. Then you're referring to BORA Section 24, which are the rights of a person charged, meaning that you have a right to a fair and independent hearing and all the rest of it, and that you should be informed of the cause and nature of the proceedings. Then you, in the same letter, and I've made this generic. Now, on the templates, anything in red, you just fill out with what the red thing says. It's that simple. Not difficult at all, people. Anyone can do it. If you've got a word on your computer, you can do it. It's that simple. Never send them the document files. If you have, say, Word 2003 or onwards, you can usually just save the document as a PDF. Always send them PDFs. Do not send them documents, because they can alter things at that end if you're sending them an open, unlocked document. PDF sort of protects that from happening, unless, of course, it's an editable PDF. So like I say, then you're mentioning criminal disclosure 2008 Section 12, which is initial disclosure, things such as your summary of facts, previous criminal and traffic history, and you're supposed to be informed of the minimum or the maximum penalty and whatnot. All of that is usually on the summary of facts. To be fully and fairly informed of the cause and nature, they must have the legislative reference in which you've broken or they allege that you've breached, such as, say, Section 40 or Section 133 of the Land Transport Acts, or Road User Rules 2004 5.1 or whatever. That just informs you of what they're saying, what part of legislation you've breached. So you go through, and this letter is, you don't have to do nothing. I'll put it all in there for you. You've just got to fill in the red bits and send it on off to tickets at police, I believe it is, let me just check, make sure I'm not wrong. Yeah, you send it off to tickets at police.govt.nz, which is the Police Infringement Bureau. Requesting a hearing, after sending that, you'll get an automatic response from them saying that they've received the documentation, and then it may take a week or up to 3 fucking months for them to get around to actually sending you at the next stage, which is usually a notice of proceedings, the charging document, okay? And on that is the next step, okay? So, we go on to Section 13. Now, the reason I mentioned Section 12 and 13 is because, remember, by requesting the hearing, you've already got a deemed not guilty plea entered. So, if a not guilty plea is entered, you are entitled to initial and full disclosure. Then I put in Section 13, all of the wonderful things you can be entitled to there: witness lists, briefs of evidence, criminal histories of any witnesses they want to pull, or the reasons why they're not calling those witnesses, or there's lots of things. Read through the Criminal Disclosure Act, Section 12 and 13. It tells you what you are entitled to, at what time you're entitled to it. That's it. Then send that letter off and away you go, okay? So that's end of part 1. That's template number 1. That's the letter. Hopefully you guys can make that out. If anyone needs help, again, just an email away, guys. CKAMark@gmail.com, and I will happily answer any questions about these templates you have. It's so simple. And simple things shouldn't confuse geniuses. But anyway, so I'll end it here. I'll move on to the next one, try and keep these clips short for you. Part 2 is template number 2, and we'll move on to that next. See you guys.